Now, the local grocery store in State College, the big chain grocery store, has like a whole section where you can buy basmati rice or buy, cumin or whatever, or you can buy mustard seeds. Those are things that were not easily available in the time of growing up in the United States in the 1980s, and certainly at the time when Vice President Harris was growing up as well. So it's pretty incredible to see now how much things have changed.
Neeraj, should we start? Yeah, please. Yeah.
So, greetings of the day to one and all present here. We at the Institute of Law, Nirma University, are celebrating International Teaching Month, a flagship event of the Institute. And this event is primarily centered for students' intellectual growth. The theme of this year's International Teaching Month is celebrating the law, life, and diversity. In the series of the sessions today, we are all here for a session on the topic, the state of Gideon, issues and challenges in defending poor people in the United States. The lecture will be delivered by Professor Gopal Balachandran. The Indian perspective on the issue of defending poor people will be delivered by Professor Dr. Balraj Chauhan. I'm hopeful that this comparative perspective of two democratic countries on the issue of access to justice to poor people will help us understand the critical areas and challenges with better insights. I, on behalf of Institute of Law, Nirma University, feel delighted and privileged to introduce our speakers of the session. Our first speaker is Professor Gopal Balachandran. Professor Balachandran is an assistant professor of clinical law, director in Externship program, co-director Indigent Criminal Justice Practicum, Penn State Law, USA. He directs the Externship program as well as the criminal appellate post-conviction track of the Indigent Criminal Justice Practicum. Professor Balachandran also maintains an active presence in international legal education by teaching legal writing to LLM students. He has presented working papers on teaching English language learners how to better read cases at Global Legal Skills Conference and has taught legal writing at Nirma University in India. Prior to his employment at the law school, Professor Balachandran worked as a public defender in Massachusetts, New York, and Maryland. We welcome you, sir. Our second speaker of the session is Professor Dr. Balraj Chauhan. Professor Chauhan is currently the Vice Chancellor of Dharmashastra National Law University, Jabalpur. He is also a president of Indian Society of Criminology and member of Committee for Reforms in Criminal Laws. Before joining Dharmashastra National Law University, Professor Chauhan has served as Director and Vice Chancellor of various law universities, including Ram Manohar Lohia National Law University, Lucknow, and National Law Institute University, Bhopal. He also holds the privilege of being member of Uttar Pradesh State Law Commission, Uttar Pradesh State Legal Services Authority, and executive member of Shastro Indo-Canadian Institute, New Delhi. Professor Chauhan holds special interest in the field of criminal law, criminology, and clinical legal education. Professor Chauhan has completed several projects funded by the state and other national and international agencies. Professor Chauhan is a distinguished scholar and awarded with Dr. Kumarappa Reckless Award for contributing to the field of criminology. He has received various prestigious fellowships, including the Commonwealth Foundation Fellowship 2011 and Fellowship of Indian Society of Criminology. He is also a visiting faculty of several national law universities and judicial training research institutes. Has been associated with the National Institute of Criminology and Forensic Science of Bureau of Police and Research and Development, Ministry of Home Affairs, New Delhi. He has also visited various international universities in USA, UK, South Africa, Italy, Uganda, Philippines, and Canada as an invitee. He has more than 40 years of experience of teaching and research. Several students have completed their LLD and PhD under his guidance. We welcome you, sir.
Thank you.
So without taking much time now I would like to request Professor Balachandran to deliver his lecture. But prior to that, as a moderator of this session, I would like to remind you once again about the protocol for the session. I request all the participants to keep their cameras on and mics on mute. I also request to actively participate in the session by asking questions in the chat box, sending them privately to me. Professor Balachandran will be speaking for 40 to 45 minutes and Professor Chauhan will be speaking for 20 to 25 minutes. We will have question and answer session at the end for 10 to 15 minutes. We welcome you all once again. Happy learning to all of you. Now it is over to Professor Balachandran.
Thanks a lot for those kind words. I'm going to go ahead and share my screen and put up the PowerPoint that I have prepared for this. Okay. So I hope everyone can see the PowerPoint presentation. Technology is always kind of a mysterious thing for me. But first of all, I really want to thank Dr. Pokhariyal and Professor Gupta for the kind introduction and for the honor and privilege of speaking at Nirma University. I have such fond memories of coming here in those halcyon days, pre-pandemic, when you used to be able to walk into crowded spaces without masks and be able to travel much more freely. I was always floored by that. I mean, I was very, it was very overwhelming and very kind of Dr. Pokhariyal and everyone at Nirma University, the kind of welcome and the kind of hospitality they provided. And I hope that sometime in the future, that can just be a repeat. Before I go and talk about the substantive portion of my talk, I thought what I would do is I'd give a little bit of background on myself. I think some of you can probably see I have a very Indian sounding name, and yet when I speak a very unaccented American English. And I think it might be helpful to provide a little bit of background on me, because like all aspects of law, and American law is no different. I think that where we're from and what kind of values we're brought up with actually inform how we interpret the law and how we view different types of legal issues that we confront. So the first thing I'd like to talk about is, so this is actually a place from my mother's ancestral village. And this is a place on the banks of the Kaveri River in Tamil Nadu. And it's a village called Manakal. And in fact, my father's side of the family, it's a temple there. It's a very traditional kind of Gopuram temple, South Indian style. And my father's side of the family is actually from just down the river in the Kaveri in another village called Vishnampete. And like many sort of South Indian families, and it's probably common with Indian families throughout this period, but in my great-grandfather's generation, they made the shift from moving from these small villages in South India to what was then the kind of town and the urban center in Tamil Nadu, which was near there, which was a place called Tiruchirappalli, which is still there. It's a very beautiful place. We've got a beautiful rock temple that you can climb up to the top of and get a nice view. And where my family went after leaving Tamil Nadu with my great-grandfather and my grandfather was actually in Kolkata. And this is a picture of the Howrah Bridge. And so my family, in fact, in a way, we were migrants within India about 80, 90 years ago. And in a way, the travel from South India to Kolkata, even though there was a pretty large South Indian community at the time in Kolkata, was still a pretty significant change. And then finally, of course, like many immigrant stories, we ended up in Lafayette City, Queens, New York. And that was the first place that we lived in. And in kind of an apartment complex like this, in fact, is where my family first moved. And then what we ended up doing, and I grew up in North Carolina, and from 1979 onwards, I have been living in the United States, and drips and drabs, my family members from India have kind of moved to the United States to such an extent that I still have family in India, but now the majority of my family lives in the United States. It's a very, very typical, I guess, in a way, immigrant story. But I think these experiences, though, do inform some of my views on the law and what some of my views are in terms of access to justice and indigent defense. So what I would like to talk about for my presentation is, I wanted to give you a little bit of background on the right to counsel, and then the current challenges that are there. And these involve caseloads, as well as the independence of public defenders' offices and funding. And then I wanted to talk to you a little bit about my experience. As Professor Gupta had mentioned, I worked as a public defender in 3 different jurisdictions with 3 different ways of administering the right to counsel. So first of all, I think any discussion about the right to counsel has to start out with the Constitution and some of the cases that have interpreted the right to counsel. So first part of the constitutional guarantee for the right to counsel involves the 6th Amendment. And the 6th Amendment guarantee is something like, that it says all of these things, like in all criminal prosecutions, it spells out a bunch of rights. And the interesting thing about the American Constitution is that each of these clauses has many, many cases that have gone on to interpret what those clauses mean and how they are applied in different courts, and in fact, even applied by judges throughout the country, as well as how trials should be conducted. But the part that I am specifically going to talk about is that final part that is outlined in orange. And that is the part of the 6th Amendment that talks about the assistance of counsel for his defense. And this is what the 6th Amendment says, that in all criminal prosecutions, that someone shall have the right of assistance of counsel for his defense. Now, it's kind of an interesting clause here, because when you read it by its terms, it doesn't say anything about what happens if you can't afford a lawyer. And in fact, actually, I think there's pretty good evidence that at the time that the 6th Amendment was drafted, a little bit of background on the Constitution. The Constitution was adopted in the United States in 1787. And these first 10 amendments, called the Bill of Rights, they were adopted at the same time in 1787. And so much of what constitutional interpretation involves is trying to figure out, well, what did the drafters of the Constitution and these amendments mean when they were writing out these words? And I think that with regards to this, there's nothing here that says anything about that you have a right to a government-appointed lawyer or that you have a right to counsel if you can't afford one. All it says in the 6th Amendment is that you have the right to have the assistance of counsel for your defense. And I think there is probably pretty good evidence, according to commentators and scholars, that what this meant is that you had the right to have a lawyer present, but that the government didn't have any obligation to provide you one. All right. And the way that I think around this time, late 1700s, early 1800s in the United States, most people just didn't have lawyers when they went in. They were called in for charged with any kind of criminal offenses. They usually represented themselves. But what this amendment did is it provided a mechanism so that if you wanted a lawyer, you could get one. You could have one. Now, what is interesting also about the US Constitution is that for a long time, the US Constitution has always been interpreted as only applying to the federal government. Like India, the United States is a federal system of government. And so it's a federal center as well as various state governments. And the majority of criminal prosecutions, in fact, occur within the state system, not the federal system. So a 6th Amendment that only applies to the federal government would mean that the vast majority of criminal cases and the vast majority of people who encounter the criminal justice system would not be bound by what this amendment stated. Now, of course, that's not actually how the history of the United States progressed. And in fact, shortly, well, not shortly, but about, close to 80, 90 years after the founding of the United States, there was the Civil War from 1861 to 1865. And what happened was is that there were that the whoops. I hope everyone can see this. Is everyone able to see the slide right now? Maybe Neeraj, if you could, yeah. Is that the 14th Amendment right now? It says that it sort of changes the relationship between the state and federal governments. And it's really through the operation of the 14th Amendment that the Bill of Rights, these rights that we talk about, whether it's the First Amendment right to free speech and all of the amendments that are there within the first 10 amendments to the US Constitution, the 14th Amendment is the mechanism by which they are applied to the states. This is it's a very important point in the development of constitutional law in the United States. And even though it seems a little kind of, how shall I say it, kind of backwards and circular in a way, which is that you have these rights and then it takes a process of the 14th Amendment and the Civil War so that it actually ends up applying to the states. And the real clause here, I've highlighted in orange, is that nor shall any state deprive any person of life, liberty, or property without due process of law. This is what is known as the due process clause of the 14th Amendment. The 14th Amendment actually also has another interesting clause, which I thought I would just point out, but it says over here, all persons born or naturalized in the United States are citizens of the United States. And there was some press about this with the Trump administration, that they wanted to ensure that people who were born in the US maybe would not be considered US citizens, but there's the 14th Amendment that kind of guarantees that if you're born in the United States, you are a US citizen. So the way that the Supreme Court, though, has viewed this clause is it's been a gradual process. It didn't happen overnight. And it's through the development of cases where the right to counsel ended up ultimately being applied to the states. And one of the most important cases that came up involving the right to counsel and the states involved this very infamous case called the Powell versus Alabama. And this is known as the Scottsboro boys case. And in fact, actually, whenever I talk about this case, frankly, it's hard for me not to get a little emotional about it because it was just so incredibly unfair. And there was really no happy ending at the end of this story. The Scottsboro boys case is a case where there were these young, I believe it was nine young Black American men in the 1920s, 30s, right around the Great Depression, who were in a train. And there was some kind of confrontation between these young men who I'm not even sure, I think the evidence is pretty unclear whether they even knew each other. And what happened was is that in the course of this, the train, they get accused by these two young women of rape. And the evidence against them was really just based on their word. And what happened was is that as this train was coming into Scottsboro, Alabama, what happened was is that there was this huge crowd waiting to lynch them. Lynching meaning they were going to go ahead and basically grab all of these young men, boys really, and execute them. And while the crowd is watching, this is actually an actual picture of that crowd that is waiting to go ahead and grab and execute these young men. Well, this is in a very, very kind of American twist, I think. And I mean this in a very ironic way. And this says a little bit about how the law oftentimes is used as, in a way, kind of a sham. During the process of this case, I believe it was the governor called in the National Guard or one of the local authorities in Alabama, called the National and said, we are not gonna lynch these young men. We are better than that. So instead, what we're gonna do is we're gonna have a show trial. And basically, while this comes up in April, at this point in time, rape, which was the charge that these young men were facing, the sentence for that was death. And so what the local authority said is, you know what? we're not going to engage in this uncivilized behavior of grabbing these young men and summarily executing them. What we're going to do is we're going to have a show trial. We're basically going to have a trial where it looks like it's a legal process. It looks like, they'll have their day in court. We'll have a trial. We'll have a jury. We'll have them sort of decide on their, guilt or innocence. And then, if they're found guilty, then the state will execute them. All right. So this trial, a capital case, capital is the term that's used for death penalty cases in the United States, was then, they had about a month. The young men were not given the right to counsel. And so then they went to trial, and not surprisingly, they were all convicted and given the death penalty, except I believe for one of the youngest young men in this. And so what happens is that this works its way all the way to the US Supreme Court in the 1930s. And in Powell versus Alabama, the Supreme Court said, relying on the 14th Amendment, said, well, you know what? These young men in a capital case, they needed the assistance of a lawyer. And so their convictions have to be overturned and a new trial granted because they didn't have lawyers to assist them. And it was the first time that the 14th Amendment was then used with regards to applying it to the state court prosecution. And so then these young men had a lawyer, and then they went to trial, and in fact, they got convicted again. And then the case got reversed again. And then it had this whole long kind of process where I can tell you the ending of the story is tragic because these young men, many of them never really got out of prison. They were, one of these young women ended up recanting her testimony, said it was all fabricated. And the jury was not representative of the population. And so, the convictions got reversed. Basically, long story short, most of these young men spent the rest of their lives in prison, or if they were released, they still had the weight of that criminal conviction. And it was not until 2013, in fact, that the Alabama Board of Pardons ended up fully exonerating these young men of this crime. And it's a very, very moving part of American history. But it's a very important case in the development of the right to counsel and how it applies to the states. So now, the question, the Supreme Court does not, and I think this is probably different from the constitutional system in India, where the Supreme Court in the United States, by tradition, it only sort of, and by actually its own sort of set of rules, it only deals with the cases that are in front of it. So the case that was in front of the Supreme Court in the Scottsboro case, Powell versus Alabama, was, do you have a right to counsel in cases where the death penalty is going to be imposed? So that's all the Supreme Court decided in Powell versus Alabama. All they decided was that you get a right to a lawyer in a situation where the death penalty is imposed. So of course the question then comes up, right? Which is, well, what happens to all the other cases, right? What happens to all the other cases that are there that are not death penalty cases? And what happens then is that there was then a case called Gideon versus Wainwright. And this is the case in which I got the title of the presentation for. This is a very, very famous case in the United States, Gideon versus Wainwright. And I'll just go through this. There we go. Okay. So Gideon versus Wainwright. This is a case in which Mr. Gideon was charged with a felony offense. And then he asked for a lawyer. And under Florida law, he was not appointed a lawyer. And this is, in fact, a picture of Mr. Gideon. And what happened is that he asked for a lawyer. The court wouldn't appoint him because under Florida law, you only got a lawyer if you were facing a capital offense. And so he was not facing a capital. He was not facing the death penalty. It was a state prison offense. It was a robbery or burglary, I believe. And he had to go and handle this trial on his own. He tried his best to sort of handle it on his own. He got convicted, got sentenced. And in fact, when he was in state prison, this is what he wrote to the Supreme Court. this piece of paper over here. And this was the Chief Justice of the Supreme Court at the time, Powell Warren. And what he did here was basically asked the Supreme Court and said, hey, you know, my right to counsel was denied. And I'm going to be asking the court that my convictions be reversed. And the Supreme Court, not only sort of incredible on this handwritten piece of paper, they take up the case, and they also rule they rule for him. Now, granted, by the time that he was going through the appellate system, he was appointed lawyers for it, so he wasn't arguing this case personally in the U.S. Supreme Court. However, in his trial court, he did not have a lawyer, and so the U.S. Supreme Court reversed that conviction and said, you know, everyone has you have a right. The right to counsel doesn't just apply in cases where the death penalty is imposed. It also applies to felony cases. And subsequent cases end up showing that the right to counsel actually also involves misdemeanor cases, which are the more minor ones. And now the state of the law in the United States is that you get a lawyer. The court has to appoint a lawyer if they want to sentence you to any amount of jail time or imprisonment. All right, nice little backstory, post story involving Mr. Gideon is that after he was, his conviction was reversed and he was given the right to counsel, in his new trial, when he did have a lawyer, he was found not guilty. So in a way, you know, you think, oh, wow, you know, lawyers are, they are very, I mean, obviously they are very important in terms of being able to advocate for people and to provide the kind of representation in the criminal justice system. However, and certainly the Supreme Court cases around this time in this 1960s, they really talk about the right to counsel in this very kind of soaring kind of vocabulary that, you know, the kind of representation you have should not depend on the amount of money that's in your wallet, for example. I'm paraphrasing here. But the reality of the Gideon case, as it's kind of gone on, has been much less, shall we say, has fallen far short of what idealism it once expressed. Okay, so there's a very important way in which the Supreme Court and the right to counsel have been kind of undergoing some stresses. And one of them is that, okay, so you get a lawyer. What does that mean? What if your lawyer is falling asleep during the trial? Now, some of you may or may not know this. This is from an old movie in the United States called My Cousin Vinny. And it's a movie that a lot of trial attorneys in the U.S. really enjoy. And this young man who was the actor in there was the public defender in the case. And he goes up there to give an opening statement on behalf of his client, and it's really, really very, very bad. So, I mean, you know, the question then becomes, you get a lawyer, but what does that mean, right? I mean, what if your lawyer is just terrible? What if your lawyer is asleep at the switch? What if they are, you know, not very good? Because the reality of criminal and trial practices is that it's very, very hard. You have to be a constitutional lawyer. You have to be an evidence lawyer, and you have to be able to know a lot of that while making split-second decisions in court. So this is no sort of knock, and I mean, having done this kind of work for over a decade, I can tell you from firsthand experience how challenging the job can be, and how many split-second decisions you have to make, and how much you end up second-guessing yourself, and how much of the law is still sort of terra incognita. So anyways, so this is the standard. Counsel's performance was deficient, i.e. made errors so serious and that counsel was not functioning as the counsel guaranteed the defendant by the Sixth Amendment. Okay? So it sounds like it's not just a little mistake. You got to make a pretty bad mistake, right? And that basically the court applies a reasonableness standard. So they look back on trial counsel's performance and they say, okay, well, did the actions that the trial counsel engaged in was unreasonable. And some of you probably can guess that a reasonableness standard is pretty easy. It's pretty easy to meet, and therefore it's very hard to find, number one, that trial counsel's performance was deficient. That's the first part about it. But so I think that this by itself is a very deferential standard to trial counsel and to maintaining a conviction. The second aspect of this is counsel's errors prejudiced the defendant. The errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. So not only do the errors have to be, pretty bad, they also have to have some impact on the trial itself. And this is the standard: reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. You can probably guess, just looking at the language of these standards, it's very, very hard to find that even if you have a lawyer like this, they are going to be found ineffective by an appellate court. And this is the case of Strickland versus Washington. Mr. Washington was convicted of a triple homicide that he confessed to. There was, the allegation was that his counsel was ineffective in trying to fight against the death penalty. Mr. Washington was ultimately executed. His case was, it was denied on appeal. But this is basically the ineffective assistance of counsel standard. And what I can tell you is that, probably not surprisingly, it is very, very hard to prevail on an ineffective assistance of counsel claim. And the way that you raise this, right, is that at trial, someone gets convicted. Let's say that their attorney made a lot of mistakes. And then the defendant then sort of says, well, my trial counsel was ineffective. They didn't meet with me. They didn't conduct the proper investigation, whatever. Those are sort of some of the main aspects of ineffective assistance of counsel claims. And then the appellate court decides, well, was the trial counsel ineffective or not? I think right around now, in terms of ineffective assistance of counsel claims, I think stats are about 10% of the time counsel was found ineffective, and that convictions are reversed. So it's very, very hard to prevail on these claims. And so just because you have a right to a lawyer doesn't mean you are going to get the world's greatest lawyer or the most experienced lawyer or the most dedicated lawyer. You just get someone to go ahead and defend you. So what this has led to, in fact, are there are a number of challenges now because these two kind of work together. You have the right to counsel through Gideon versus Wainwright, but then you have these ineffective assistance of counsel claims that say, well, your lawyer doesn't have to be, just kind of has to be not that great. That'll be fine to pass constitutional muster. And so what's happened is that these are some of the current challenges now that the criminal justice system, the indigent defense system is facing, and that they are caseload issues. This is probably the biggest, which is that a lot of the public defenders working just have too many cases. That is problem number one. There's also a problem with independence. And then finally, there's a problem for funding. I put for experts, but it's funding in general. And then because as I will explain to you going forward, the issue with current issues with indigent defenses is that, especially for felony cases, they are heavily expert driven now. You deal with forensic evidence all the time, whether it's DNA, whether it's fingerprint, whether it's psychological experts, whether it's experts to deal with polygraph, whatever. You have to hire a lot of experts, and that can get very, very expensive. And frankly, as defense counsel, sometimes you're basically scouring the country to find people who can help you on cases so that you're best prepared for trial. So before I go into some of these challenges, there's one other thing that I think bears pointing out. This is a map of the United States, right? The United States is a big, diverse country. We're in Pennsylvania over here, or else, I am right now. And basically, every jurisdiction in every state has a different way of handling how poor people get lawyers. So the system in New York, for example, is different than the one in Pennsylvania. The one in Pennsylvania is different than the one in Ohio. The one in Ohio is different than in Michigan. They're different from California, different from Nevada, so on and so forth. And so when we're talking about the delivery of representation and access to justice for poor people, you're really talking about 51 systems. Because not only do you have different state systems, there are also federal systems that are different as well. And the federal system is completely different than the state system. So how does the delivery of lawyers work for the states, for the different state systems? What does it kind of look like if you were going to sort of try and make any kind of general statements about it? Well, this is what it's generally looks like, which is that in 24 states, there's a state level public defender office. 7 states have a mixed state and local. This means that it's a state level agency. And 19 states, it's local. They have a county public defender or they have assigned private counsel. That means that when I say assigned private counsel, what that means is they are not government employees. They are just private lawyers who take criminal cases. So the system is different and it depends on where you live. The interesting part is that there is some state money that will usually filter down into the public defender system, even at the local level. However, there are 2 states in the country where the state government provides no money for indigent defense. 2 states. And those states are Pennsylvania is one, and South Dakota is the other. Those are the only 2 states where at the state level, there is no funding for indigent defense. So for example, Penn State Law is located in State College, Pennsylvania, which is located in Center County, which is the name of the county that we are located in. And the public defender's office here is fully local, which means that it's a function of county government. It is not a function of state government. It is not a function of federal government. And in fact, they get no money from the state or the federal governments. So what is so I think, the important question is that what kind of impact does that have on representation? And I think generally speaking, some of the studies that I've seen show that if it's a state level office, they tend to provide better representation and better resources than ones that are local. And that public defenders tend to work better than assigned private counsel. That's at least, some of the data out there. And I think, my own anecdotal experience, the places that I worked in were New York, which was a county system, Maryland, which was a state system, and Massachusetts, which was a state system. And the state systems, from my experience, function a lot better than the county systems. For some of the reasons, I'm going to go into some of those right now. But basically, the upshot here is that depending on where you live and which part of the country you're in, the type of public defender offices are going to be different. Now, one of the biggest issues right now is caseloads. When I'm talking about caseloads, what I mean by that is the number of cases that you individually as an attorney have that you carry. The ABA, the American Bar Association, they've come up with different numbers in consultation with various criminal justice organizations about what the maximum number of cases, like say if you're handling felonies. And by the end of my career, I was only handling felony cases. I was handling the cases where my clients were charged with rape, with murder, with serious drug offenses, with child sex abuse, all of those very, very serious cases where if your client is convicted, they end up doing a significant amount of time. And they also have a lot of forensic evidence and all of that. So they have different types of standards by which how many cases you ought to carry. And so the reality is the number of cases in the criminal justice system have gradually increased over the years. And this is because of what's been dubbed the war on drugs. There's a lot of drug offenses. There's also been a lot of tough on crime policies. And what that's meant is that in a lot of places, you've basically doubled or tripled the work. And it's hard to sort of describe what this kind of does to someone working in that system. And I worked in the jurisdictions that I worked. In Massachusetts and in New York, I had some caseload controls where the number of cases I worked on was sort of limited. In Maryland, it was not. There was no sort of caseload control. We got what the court gave us. And it's hard to sort of describe what that means when you're carrying so many cases all the time, and that you have different people who are, many of the clients you have, especially in serious cases, they're incarcerated, you have to go to jail, you have to do investigations, you have to hire experts. The amount of work that it requires, it's just simply too much for any human being to be able to do. And that was in a jurisdiction that wasn't as bad as some of the ones that are there in the United States. Places like Missouri, right over here, I'll just show the map, right in the central part of the country. They have been notorious and have been subject to a lot of litigation in terms of how many cases attorneys have to carry. Louisiana is another one, where the attorneys carry so many cases, it's just impossible to be able to do an adequate job defending individuals accused of crimes. And keep in mind that the way that Gideon provides a lawyer, but then with Strickland versus Washington, it doesn't really mean the lawyer has to be that great. It just has to be a lawyer. So, so this is probably one of the biggest issues that that attorneys in the criminal justice system face, is caseloads, and this is something that you'll hear about it a lot in the debates on indigent defense in the United States. The other thing is that you need experts. I had one trial in upstate New York. It was a child sex case, and what happened was that I hired a psychologist, I hired a polygraph expert, I hired another psychologist, I hired luckily I didn't have to hire this, but I basically had to sort of talk to different medical professionals involving physical injuries. And that was on one case. That was on one case, and my caseloads were sort of controlled. And if you start to sort of, you have more, like you have DNA evidence, you have other types of forensic evidence, the universe of experts just kind of increases and different issues come up, right? I had one case where we had to hire a DNA expert, and not only that, we had to send our expert from Massachusetts down to Texas, because that's where the lab was conducting the test. And that test that we had to, they were going to use all of the sample from the case. So I had to have my expert basically in the room observing the test to make sure that it was done properly, right? I mean, this is what people deserve, right? This is what it means if you have an ideology, which is there in the cases, that the type of representation you get should not depend on how much money is in your wallet, right? So you have to be able to have these experts. That meant that the agency that I was working for, this was in Massachusetts, we had to, hire the expert from, I believe it was from Boston University, a PhD, DNA scientist. We had to fly her out to Texas. We had to, book her up in a hotel room. We had to cover the costs of, other types of screening she had to go through because of a private lab. And that was for one case. I mean, it was easily over $10,000 just for that one expert. And when you start adding that up, it can be very expensive. And especially for smaller countywide systems, they don't have the funding to be able to handle these experts, or you have a lot of roadblocks that are put forth in front of you. And this is where the other part about this independence comes in. Especially in county-wide systems, what happens is that you don't have independence in the same type of way that you have with the state system. This is some anecdotal experience, but I think it's also borne out. But in one county in upstate New York that was sort of a neighboring county of where I was working, what happened was is that the local public defender's office, they started to, file a lot of motions. They started to fight all of their cases in a particular kind of way that the local county administration did not like. So what the local county government did was they just canceled their contract. And they said, from now on, we're going to go to a different system. We're just going to have private lawyers. And these private lawyers, the local administration was able to control. And even now, when you have county systems that sort of are working, county-wide public defender systems that are funded by the county government, there's a lot of dependence on their funding from the county government. So you cannot, basically, you can't make, you have to be very careful about not making the wrong people angry, or else, you sort of lose the ability to have that particular kind of agency and that particular ability to represent people. It's a real issue, especially because in these more local offices. And it's once more a subject of a lot of debate and discussion among policymakers and academics in the United States. So what does, I think it's a kind of once more, I sort of mentioned a little bit about my personal experiences to start out my talk. And I wanted to sort of give you a little bit of a flavor for what it was like when you were working as a public defender. And this was an overburdened public defender office, but mind you, it's not nearly as bad as many places in the United States. This is what I would say a typical week would look like. Mondays, you have probation hearings. So you're in court much of the day. It could be 20 different clients, 30 different clients, sometimes even more that you have. And this is pretty good, right? If you only have 20 to 30 different clients on a Monday. In many jurisdictions, you can have 100 individuals for probation hearings. That's your Monday is sort of taken up with this. Tuesday is felony jury trials. So you have to go into court, and that's the day in which trials are scheduled on Tuesday. So then you have to go into court, and then you're ready for trial, or you're not. And then if you're not ready, then you have to ask to get your case postponed. The judges will get really upset with you. So a lot of times they will deny your request. Wednesday are your felony/misdemeanor jury trials. This is another very, very busy day in the court. Thursday is another felony jury trial day. So you have Tuesdays or Thursdays. And then Fridays, you have pretrial conferences. And that's also sort of like a very heavy day. So keep in mind that as a defense attorney, as a public defender, you have to go to the jail to visit people. You have to conduct investigations. You have to prepare. You have to read up on the case law. Like I said, it's a very difficult job in the sense that and it's also a wonderful job because there's a lot of not just sort of, in court kind of advocacy. There's all of this kind of thinking work in terms of constitutional law, evidence law, that you have to be familiar with and be able to know off the top of your head so that you can make the right type of objection and the right type of arguments for your clients. So there were times when I would have a month where I was in court every single day. And on the weekends, I would have to prepare for cases, see if I can beg or talk to experts or psychologists or whoever I was going to hire for different types of cases. And mind you, by this point in time, my caseload was almost all felonies. And so I would probably carry anywhere between 80 to 100 felony cases at any given time. And they involved a lot. There was a lot of homicides by the time that my career was ending in Maryland. And, there were a lot of homicide cases that all of us were carrying. And there were times I've had a felony jury trial start here. That would take 2 or 3 days. Then I would start another felony trial on Thursday. Then it would last through Monday, and I would start another one. I think I had 3 felony trials that were back to back to back that I just had to try where I couldn't get out of them and just had to do your best. And so obviously that has an impact on the kind of representation you can provide. So, so the upshot here is that the right to counsel is guaranteed by the 6th and 14th Amendments of the Supreme Court case law. That's the legal framework by which poor people get lawyers in the United States. But each state and the federal government has a different system to deliver lawyers for poor people. And they lead to different kinds of outcomes and they have different aspects to them that make them better or worse, I think. And then finally, the right to counsel, the right to counsel is not a cure-all for all, as ineffective counsel claims are hard to win and doesn't prevent systemic problems in indigent defense. And finally, the caseloads, the lack of independence are among the biggest challenges right now for public defender offices. So I look forward to continuing the conversation and learning more from Professor Chauhan. Thanks a lot for all of your time and your attention.
Thank you.
Thank you, Professor. Now I would request Professor Balraj Chauhan sir to deliver his perspective on right to defend defending poor people. Over to you, sir.
Thank you, Professor Neeraj. At the outset, I would like to convey my appreciation and gratitude to the organizers for providing me this wonderful opportunity to be on the panel where really we are discussing a subject of immense importance. Professor Gopal Subramaniam is having the experience as a public defender as well as a professor, and he's the right person to speak on this issue of a public defender, and especially the topic which he has selected, the state of Gideon's issues and challenges in defending poor people in the United States. I'm happy that Professor Subramaniam discussed the American rule of due process. And in fact, I am thankful to Neeraj also, because when the day one I received that particular mail and I saw the topic, I just asked the Neeraj and Purvi, you two also, that what is the concept note of it? Because we are not using this term public defender. Of course, I could get it when I tried. I have visited US. I have taught comparative criminal law there in Baltimore and other places. But believe me, we are working as a clinician, a clinical law teacher in the legal aids and otherwise. But when this term came before me, and then I tried to find out that this is the term of public defender, which is being used in USA, which literally means a lawyer usually holding the public office, whose duty is to defend the accused person unable to pay for legal assistance. I'm telling it for the sake of my students who are attending this session. Because we use the term public prosecutor office is here. And when Professor Subramanian was talking about the public defender's office, and he was talking about the workload and everything, and the different procedure in the different states. Of course, he could share all these experiences because he himself has worked, and you were lucky enough to have the first-hand information from him. However, when I talk, dear students, you will have to understand that in our Indian legal system, access to justice and the right to fair trial are considered as a human rights, and they are guaranteed to all accused. And you know, the evaluation of law which has taken place in our country, it is interesting that the analogy of the law was removed by the Supreme Court. And finally, they reached on a particular settled law in Gideon case. But here in our country, if you see our system and especially the constitution, because before that, I would like to just mention about Sir Alfred Draining when he said, I quote, because all these discussions we are making for the better dispensation of criminal justice. He observed, I quote, justice is not something you can see. It is not temporal, but eternal, unquote. Further, he mentioned, how does a man know what is justice? Because it is not the product of his intellect, but of his spirit. I always start looking towards the accused, victim, from this particular observation. Because ultimately we are engaged in a process of justice. And my dear students, you know pretty well that the substantive law and the procedural law both play an important role. And you are supposed to do mastery over the rules, regulations, and how we are trying to develop you with all these developments. So, if I start like Professor Subramanian started with the 6th Amendment and the 14th Amendment of the USA, I can say that the Constitution of India is built upon the foundation of democracy, rule of law, secularism, free and fair elections, federalism, judicial review, and not too rigid separation of power. In fact, Constitution of India is the goal-oriented, policy-oriented, and welfare state-oriented document of the land, and its preamble provides the human tone and temper of the Constitution, which emphasizes, among other things, justice, equality, and dignity of the individual. This was the observation made by the court. And in this regard, when I started with the access to justice and right to fair trial, the concept of access to justice is deep-rooted in the history, enshrined in the Constitution, sanctified by religious philosophy and juristic doctrines, and embodied in the statute intended to regulate the course of a criminal trial. Because of this Constitution, we are having the uniform administration of criminal justice throughout the country. And as far as accused are concerned, I know that my students are knowing that there are 3 very important articles in the Constitution. Article 20, Article 21, and 22, which are just like Quran, Gita, or Bible. Because for a practitioner of law, for a judge, these 3 articles play a very important role in the dispensation of justice. Article 20 deals with 3 subclauses: no ex post facto application of criminal law. Second, no double jeopardy. Third, no person can be compelled to be the witness against himself. Article 22 has become a springboard. And why I'm saying so? Because the way it was interpreted in Maneka Gandhi case in 1978. Here, I would like to give you some information that though we are talking about the right to counsel to an indigent accused, in our legal system, before 1974, there was no statutory mechanism for such type of right to the accused. In 1973, when we gave new CRPC to ourselves and it was notified in 1974, Section 304 was added, and 304 specifically provided the right to the accused who were appearing or who are appearing before the Sessions Court. And you can understand what type of cases are brought before the Sessions Court. This particular right was given. However, I was trying, because when we discuss the development of the USA law and we compare it with our country, these three articles, and especially Article 21, no person shall be deprived of the life and liberty without the procedure established by law. And this procedure established by law was read by or interpreted by the Supreme Court as due process of law. And they said, no, this procedure must be just, fair, and reasonable. Section 304 was there. Article 20 was interpreted this way. And that started, you see, in 1980, Khatri versus State of Bihar. Before that, Husainara Khatun. Because in both these cases, the Supreme Court expressed its displeasure that thousands of prisoners are languishing in jail without any legal assistance. They may be guilty of the petty offenses, they may be guilty of the offenses which may be tried by the judicial magistrate or the chief judicial magistrate, but they were not provided the adequate legal assistance, so that they were in jail. Specifically in both the cases, Supreme Court directed the state government that provide legal assistance to these persons so that they may get the advantage of the Article 21, no person shall be deprived of the life and liberty without the procedure established by law. Article 22, you see, in many cases, which I will put before you, right to engage a lawyer of his choice. Other safeguards of the 14th Amendment, which my friend was discussing, they have been included in Article 22. And Article 22 provides when a person, Article 22, it is in two parts. First part deals that all the persons arrested, they must be produced before the magistrate within 24 hours. The next clause Article 22, protection. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. This word, by a legal practitioner of his choice. Some people tried that here, when this right is being given to an accused, he should be allowed to choose a lawyer of his choice. And especially in the cases where, because I was just going through the number of cases, and in Ranjan Devedi versus Union of India, 1983, in Sukhdas versus Union Territory of Arunachal Pradesh, 1986. In this case, Supreme Court observed that even if an indigent accused has failed to apply for the legal aid before the Sessions Court, even then the magistrate is bound to inform every accused who on conviction is liable to imprisonment, and this particular right is a fundamental in nature. In the case of Raju versus State of Madhya Pradesh 2012, and in the case of Muhammad Ajmal Amir Kasif, you see, I will take it afterwards, but before that, I would like to discuss very important observation I had. Yeah. Because the changes which has come in our system, and yes, I can say that they have been influenced by the development in UK, USA. Judges are taking a cue from those judgments. The traditional view expressed by the Supreme Court on the interpretation of Article 22(1) of the Constitution, that right to be defended by a legal practitioner of his choice, could only mean a right of the accused to have the opportunity to engage a lawyer, and does not guarantee an absolute right to be supplied with a lawyer by the state, has now undergone a change by the introduction of the Directed Principle State Policy embodied in Article 39A. In 1976, 42nd Amendment was made, and a new Article 39A was added in the Constitution. And according to 39A, which titles Equal Justice and Free Legal Aid, the state shall secure the operation of the legal system which promotes justice on the basis of the equal opportunity, dash, dash, dash. So what I want to highlight from 39A, Maneka Gandhi case, Khatri, and Husainara Khatun afterwards, in our country now it is well settled, and I can say that it is the duty of the trial court, it is the duty of the magistrate, while an accused is produced before him, even for remand, even for the first time, to inquire about whether he is capable of engaging a lawyer, or the state should provide him this particular facility. I'm not sure, because I will ask this question from Mr. Gopal. Here in India, right to counsel, okay, it has been accepted. But right to engage a particular counsel, we are not allowing the accused. Though Article 22 talks about the lawyer of his own choice, but it is there where he is engaging a lawyer of his own. But when it is the state which has to engage a lawyer for him, can he ask for the engagement of a particular lawyer, and can he demand, no, I don't like him, I like this lawyer, I like that lawyer. So this right stands on what footing? Okay, theoretically we are saying, but if that person is not satisfied with the services, however, there have been some cases I was trying to find out, and I was just, Neeraj, you know that Vice Chancellor's position is a very difficult position. In spite of my best efforts, I couldn't manage much time for this, but definitely I'm going to work on it because I was attracted. There are 4 or 5 areas which I will come back to you, which requires deeper attention, deeper discussion. And those areas, number one, because the one case which is in front of me, in 2012, Supreme Court decided a case named Muhammad Hussain versus Union of India, and it was decided by Honorable Justice H.L. Dattu and Honorable Justice C.K. Prashad. This was the case on 27th February 1998. Police registered a case, wide FIR number, under sections 121, 121A IPC and section 345 of the Explosive Act, as well as under section 25 of the Arms Act at main Delhi railway station on the basis of information provided by the apprehended terrorist. Police made more arrests, including that of one Muhammad Hussain, who now is the appellant before us, before the Supreme Court in this particular case. What happened after the investigation? Police submitted the charge sheet, trial court convicted the accused, then they went in appeal before the High Court. High Court convicted them. This Muhammad Hussain, who was a Pakistani national, he came before the Supreme Court and he asked for certain remedies. First thing he said that I was not given the lawyer of my choice. Initially, but the records which were given there, it was shown that he was asked whether you would like to have the state counsel. He asked for the Pakistani lawyer, which was refused. And later on, one lawyer was given to him, and that lawyer worked for him in the trial court as well as in the High Court. But when the matter came before the Supreme Court, and you see, very interesting observation has been made by the Supreme Court in its judgment. I'm just reading that. The records would disclose that during the committal proceedings before the learned magistrate, the appellant was assisted by one Shri B.K. Jain, a learned counsel employed by the state. He continued till the case was committed to the Court of Sessions Judge. Before the said court, one Mr. Feroz Khan was employed by the state to assist the appellant. He participated in the proceedings before the session judge only on a few days of the trial, and after he stopped attending the proceedings, that too at the fag end of the trial, another learned counsel was appointed to assist the appellant. The record reveals that the evidence of 56 witnesses out of the 65 witnesses examined by the prosecution in support of the indictment, including the eyewitnesses and the investigation officer, were recorded by the trial court without providing a counsel to the appellant. The record also reveals that none of the 56 witnesses were cross-examined by the appellant accused. It is only thereafter the wisdom appears to have dawned on the trial court to appoint a learned counsel on 4th December 2003 to defend the appellant. The evidence of the prosecution witnesses from 57 to 65 was recorded in the presence of the highly appointed, freshly appointed learned council. So this matter, this record was produced before the Honorable Supreme Court. And Mr. Subramaniam, I am asking you this question because you have been a public defender and you are knowing the inner things of the trial. Is it happened in USA? Because I will come back to you, because here in India, a lawyer who was given to a particular accused stops assisting him, some other lawyer is appointed. So this change, definitely we will agree that it affects the quality of the lawyering, it affects the quality of the outcome, and similar for the same reasons. Supreme Court accepted the prayer of the accused and they went for the fresh trial. It seldom happens. In this case, the Supreme Court allowed the fresh trial, and law students should read this case again and again, because this is one case where we can understand that what type of problems may arise, may come when an indigent accused or a person who is in need of a lawyer comes within the net of the justice system. Because ultimately I said justice is not temporal, it is eternal. And how the accused is feeling, how the state is feeling, state is just fulfilling its constitutional duty by mechanically appointing a lawyer, or the words which have been used in Article 22 would apply to such type of counsels also who are being given to the accused under the right to counsel, under the right to defend by a lawyer. And of course, you will agree with me that right to free legal assistance is available in most of the offenses which are punishable with death sentence or life imprisonment or serious offenses. But in our country, there is a debate, and the courts have given their judgment, because I was reading one judgment. It was Shri Chand versus the state of Madhya Pradesh. In this, the court said that the right to free legal assistance is available in cases where the offenses are punishable with substantive sentence of imprisonment only, and not when punishable with fine only. What is the position in USA? Because the offenses which are punishable with fine only, whether the accused is having the same right to be defended by a public defender, or it is the same as it is in our country. Because again, the debate is going on. The poor people, the poor persons who are finding it very difficult to survive, to fulfill their basic minimum needs. And if they are charged, they may be illiterate, they may be mentally disturbed, whatever it is, because even the educated persons don't know the nuances of the law. And therefore, this due process of law of USA, or the constitutional safeguards provided under the Indian Constitution to a particular accused, are sufficient. I feel that every case is a different. As a criminologist, I always feel, because what we are doing in criminal law, we are trying to punish a person on the basis of the act. And Purvi, I am of the opinion, and I hope that you are capable and you will organize a sort of conference when eminent professors like Steve and Subramaniam and others may join, Because I think that we should punish according to the actor. We should not punish on the basis of the act. We, as a criminologist, we know the theories of the crime causation. And we know that the actor is important or the act is important, because whenever we talk, if a theft has been committed by a minister and the theft has been committed by a person who was not having enough money to fulfill the needs of his family, the punishment is same, up to 3 years, 379. And here, minister is getting all the support. Battery of lawyers are standing, because the criminal justice walking cake model, I always discuss, those people can arrange battery of lawyers with them. But this person, yes, state will provide the lawyer. Lawyer will be more interested how much money I am going to get from this particular case. How many dates are there? And I will tell you, or I will share one case. Professor Pandey was telling that there was a Lok Adalat in Delhi. And an accused was brought before the Lok Adalat. The prosecution has charged him with the cycle theft, bike stealing. So when he was brought before the court, the prosecutor asked him, and the lawyer who was arranged by the State Legal Services Authority to defend him, both of them were there. And you know, Professor Subramanian, you might be knowing that India has enacted Legal Services Authority Act, and now we are having the National Legal Services Authority Act, we are having the State Legal Services Authority Act, District Legal Services Authority, as well as in the Tehsil Legal Services Authority. And these are the authorities which are responsible for providing legal aid, including the legal assistance to the accused. Anybody who is in need of the legal assistance, or it is not like a right to counsel, because under 304, it's a specific right which has been created in favor of the accused. Because, may I read section 3041? It says, where in a trial before the court of session, the court is not represented by a pleader, and where it appears to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. In such type of cases, it is the right of the accused and it is the duty of the court to provide him a lawyer at the expense of the state. In a public defender system, it is the state which has appointed a cadre of public defenders. But here, it is the discretion of the court to appoint a lawyer to a particular accused, and therefore, but you know, Sessions Court, all offenses which are punishable with the death sentence, life imprisonment, or more than 7 years, I think in most of the cases, such type of offenses, heinous offenses. This section doesn't apply on trial courts presided by the judicial magistrates or the chief judicial magistrates, where the conviction is up to ordinarily 7 years. There, this right is emanating from Article 21, Article 39A, and Legal Services Authority Act, Section 12. Students, please remember it, because when you are doing clinical program, your director, Dr. Purvi, might have taken you to the prisons and she might have asked you to interview the under trial prisoners. She might have asked you to interview the prisoners who have been convicted, or because under trial prisoners ordinarily are not allowed by the jail officials to interact with anybody. But when they are confirmed that these people, they are the persons who are not going to create any problem or nuisance for them, and they will be helpful in providing the legal aid or legal awareness to the under trials, they allow. So now I think as a clinical law teacher and a professor, you might also be experiencing such type of things in day-to-day work. I remember when there was a strike, Bar went on a strike in Lucknow for more than 15 days. After 2-3 days, I was contacted by the brother of an accused. He said, my brother is in jail. Advocates are not appearing. Judges are sitting. What should I do? I was a young teacher and I said, okay, we will see. And next day I went to the court. I talked to the district judge as well as additional district judges. They said that if any lawyer wants to come before us, he is welcome, but we will not ask anybody to come. Manaka sir, these are the cases, bail cases, and they are languishing in jail. It's a clear violation of Article 21. But they suggested me you try to find out some solution with the bar. I went to the President Secretary of the Bar Association. Initially, they refused to talk anything, but some of the advocates who have been my students, they said, sir, what you suggest? I said, I can do one thing. Persons who are in prison, who are in jail, if they want their case to be contested by us, because under the Advocates Act, teachers cannot appear as a lawyer in the court of law. However, the next friend may appear before the court. So this was the, I think, discussion which we had with the district judicial authorities. And they said it's an exceptional circumstance, and so we will allow. So from third day, and we said that we will not charge any fee from the client. We will not charge any fee from the accused. And whatever fee is required to be given, that person may give to an advocate if advocate would help us in this process. Believe me, we started with 4 or 5 cases a day. Within next 8 or 10 days, we represented in more than 60 cases, and out of them, we got bail in 40 cases. They were only the bail cases, and they were contested by the students, postgraduate or undergraduate, or by the teachers like me. And that was a wonderful experience for us. So as far as our country is concerned, when Professor Madhav Menon was there, I was always advocating for allowing the teachers to practice. I was very happy to see in USA, especially in Catholic University, Baltimore University, students were appearing before the court under the supervision of their teacher, supervisor. And these are the opportunities which makes it professional. So as far as you see, public defending is concerned, we are not having this concept in our country. But as far as right to have a counsel by an indigent person is concerned, it is now well protected, well recognized. And this Article 21, Article 39A, and of course, Section 304 of the CRPC is also allowing us to help those indigent persons. But I'm not sure about the satisfaction level. And I will also know, because Professor Subramani, you were speaking so nicely, but in between you, because I know there are very good agencies have you tried to find out the satisfaction level of these accused after getting the assistance from the council? They were satisfied, they were not satisfied, in how many cases? Because here we have not been able to collect this data. As a criminologist, Purviji, it is our duty, because nowadays I am president of the Indian Society of Criminology. And I am telling my friends again and again to go for out-of-box thinking and for some innovative projects. Because I want to promote a spiritual criminology also. So that, because you were talking about the provision, you were talking, so those are the areas where we can take the help of the spiritual criminology or something like that. We will talk on that someday else. So I would like to thank Purvi for providing me this wonderful opportunity. And Neeraj, thank you very much for helping me and providing me good inputs. And of course, I was very much impressed, because the way the law was developed in USA through Powell versus Alabama, Brett versus Brady, and especially this case, Gideon versus Wainwright. But you know, we feel very happy. But again, lot of way to go. Dil mange more. Something more is required, because justice is not temporal, it is eternal. Thank you very much.
Thank you, sir. It was indeed a very thought-provoking sort of lecture. And now the floor is open to questions. So Gopal sir, would you like to respond? Because I saw you eagerly waiting to respond to the questions which Professor Chauhan has posed.
Oh yeah, so yeah, you know, the question that I was in terms of the lawyer, whether you're not happy with the lawyer, and then you're saying, well, you've appointed a lawyer, I don't want lawyer A, I want lawyer B, or I want lawyer C. Yeah, most courts are not going to do that. And I mean, I'm not sure that there is. I think the thing is with the appointed counsel is that you get what you get, and that's just kind of how it is. So I don't think you have a right to sort of say, I want lawyer X or Y, who's just appointed a lawyer. That's it. So that's the main part about that.
Thank you, sir. So we have a question from one of our faculties, Ms. Taruna Jakhar. And the question is to Professor Gopal. And she's asking that in 2017, Federal Committee had recommended Congress to establish an independent/ad hoc commission to look after the working of public defenders. The question is, if this committee will be established by Congress, and in a hypothetical situation, if retired judges are appointed as member of the committee, how can the independence from political or indirect judicial control of public defenders be rules out in such a situation? So the independence and the supervision, that is the question.
No, that's a great question. The thing about congressional committees, though, is that many times they are there to study a problem. So what they will oftentimes do is that when Congress sets up these committees, they will look at a particular issue and then they will provide advice to Congress. But given the federal system in the United States, like India, whatever occurs with Congress only applies to the federal system. So say it's not going to, they might make recommendations to Pennsylvania, for example, where Penn State is located, but it's not going to be binding on Pennsylvania. See what I'm saying? So I mean, so I think one thing is that if they are retired judges, and usually the way these committees work is it's like they're information gathering. So they're not necessarily going to be involved in the actual administration. I think that would be more of an issue if they were actually sort of taking over the systems. But usually they're just sort of information gathering. And number two, they don't have an impact on state systems. And even with the federal system, there are federal systems that are there throughout the states and different judicial districts. So it's very decentralized. So I think in a weird sort of way, I think India has a bit more of a centralized control, whereas in the United States, it's very, very decentralized. So even part of the same system, even if they were engaging in some kind of control, which I don't think it's going to involve, it's going to be decentralized.
Thank you, sir. So another question which we have is from one of our students, Shruti, and she's asking the question to Professor Gopal again. And she says that why quality legal aid does not make to manifestos of political parties or is not of that importance compared to healthcare/education sector, budget-wise too, even when it well settled principle that it is the duty of state to protect the right of all in front of law. And further, how can a state be successful in increasing the quantity as well as quality of public prosecutors/experts of law?
No, that's a great question. Well, I guess one thing I would say is I would distinguish between public prosecutors and public defenders. So, I mean, the public prosecutors, they have their own kind of funding issue. They're on an arm of the state, but generally speaking, they get better funding than, say, the defense side. And, it's a very important political issue. I mean, it's come up now more recently where people are recognizing it. But for a long time, elected officials, they're not going to run on a platform of, we need to help those people who commit crimes out, right? They're like, we need to make our streets safer. And that's more of a winning political message than it is to say, well, we need to have a fairer, administration of justice. We need to have more rights for people who are accused of crimes. So I think that there's been a real problem in the United States historically. I do think some of it is changing now, and that there's greater recognition about the role of indigent defense and the rights of the accused, but that's still it's still a significant hurdle.
So now we have one question to Balraj sir, and the question is basically on the role of magistracy and the current scenario of fake encounters. I mean, one of the students raised this question as to how Sakiri Vasu is not being properly implemented in its spirit, and what is your call on the fake encounters which are happening nowadays? So these are two questions. Actually, I've clubbed it for convenience.
Thank you, Neeraj. In fact, you see, she has asked the whole criminal jurisprudence. Fake encounters. How you label them fake? Number one, through media or after judicial inquiry. We are labeling every encounter as fake encounter. I think it is not correct. Under CRPC, there are provisions that after the encounters, inquiry will be made by the magistrates. And you see what happens? We jump on conclusions. And we are passing through very difficult times, believe me. I was invited by the Symbiosis Hyderabad, and I was supposed to speak on the administration of criminal justice. And that particular morning, there was a news that 2 rapists have been, I will use the word killed, but police was alleging that it was an encounter, and they were killed in an encounter when they were trying to escape from the scene of occurrence. You remember one veterinary doctor was raped by the two persons, driver and the cleaner of some truck which was there. And media and everybody was saying how it is possible. They were arrested by the police. They were taken to the police station, and why they brought them in the wee hours of the day. At about 4 or 5, they were taken back again to the spot. And when they were on the spot, they tried to escape and they were killed up in that encounter. That thing was going on, but the people of the Hyderabad, they rose. Dear, I will answer your question because as a law student, you should believe only on the basis of evidence. Yes, it is a problem with our police, or it is a problem of the administration. This is a problem of the state. Learn more political theory. Law and politics both deals with power. And balancing of that, you see, why law has become a very important discipline nowadays. Why you should learn more and more about the science of law. Because a person gets redressal only through law, ultimately. Otherwise, state is the most powerful agency. Critical criminology, you see, पूर्वी जी कुछ पढ़ा रहे हैं आप लोग critical criminology है नहीं इन लोगों को? Critical criminal law, you are teaching them or not?
In the senior semester, yes.
The senior semester. So then they will not ask such type of questions. It's a matter of evidence. Don't go on hearsay. And number two, Niranji, what was her question?
Sir, Sakiri Vasu, implementation of the guidelines as given in Sakiri Vasu.
DK Basu.
Sakiri Vasu, sir. Sakiri Vasu.
Shakili Basu.
156.3, sir.
Okay. Yes. You see, 156.3. We are discussing this particular provision nowadays in our Criminal Law Reforms Committee. And some are of the view that affidavit must be made compulsory. Some were of the opinion, no. It should go like it because the practice which is prevailing nowadays in our court is every person who is approaching the court to file a complaint, he must give an affidavit that he tried to lodge an FIR. But my question was, again I am putting that justice is not temporal. Justice is eternal. It depends upon the spirit. And those guidelines which have been given there, I think Professor Vajpayee, Professor Vajpayee will tell you that we had more than 2 hours discussion.
Yes.
And even then we could not reach to any conclusion. What is the best way? Because a person who is approaching the court after being neglected by the police officers, other things, or if a person, unscrupulous person is approaching the court and is getting the advantage of the 156.3 order passed by the magistrate. But the whole question is, I just told this thing and I'm telling it today. Our judicial systems revolves around the consciousness, knowledge of a judge. It is the judge who gives life to the system. Systemic problems may be there, but if the magistrate is good, magistrate is able to understand, because Professor Pandey usually talks about the Ramcharan Yadav case, where when a person was brought for the remand, and the Darogaji asked the magistrate just to sign the remand order. Magistrate said, no, I would like to see that accused. Bring that accused in front of me. Police officer said, no, sir, he can't come because he is having some injuries, some problem. Well, okay, I will go and I will see. Magistrate went along with him and they saw that whole body was blue. He was beaten mercilessly. Magistrate charged the station officer. He died. That accused died afterwards, and he was convicted for the murder. But it could have been possible only because had the magistrate remanded him for judicial custody, things would have been entirely different. So these are the issue which requires lot of empirical data. Purviji, these are the issues where we look towards the Supreme Court or the High Court for their judicial opinion. And similarly, same is the case with this direction. Why they are not applying it or not? I think it may be the ignorance of the judge, it may be ignorance of the lawyers, or it may not be convenient to them to follow those guidelines. Convenience. So on the policy level, because today's discussion, what we had, I'm more thinking from the policy point of view. What should be the policy of the government? Only a mechanical duty? Oh, give a lawyer. Will the consent of the indigent accused is not required? Okay, I am fine with this lawyer. Mr. Gopal Subramaniam, please tell me, is there any consent letter from the accused side to the defender's office that, yes, sir, I agree for this nomination?
Like consent letter, like what does that mean, a consent letter?
Pardon?
You were asking about a consent letter.
State has appointed a lawyer, a defender. You see, there are 10 public defenders, and one of them have been appointed by the state for him. Will the satisfaction of the accused is required? That yes, no.
No, and in fact, actually, the way that the appointments work, it's not, well, a lot of times it's the courts that end up appointing. So it's the judiciary that ends up appointing the cases. So, I mean, a lot of times it's not really, I mean, the public defender's offices, they sort of have some say in it, but the accused is not going to say, well, let's say I'm working in an office with 10 lawyers.
Yeah.
It does happen, right? I mean, it does happen where they'll say, well, I want him, but not her. I want her and not him. And, the offices generally, they have the control. They'll say, no, you get who you get.
Yes. So I hope that my dear student will be satisfied by what I've told her and read more, try to collect more empirical information. And
Thank you.
Thank you, sir. So we have already overshot time, so we'll not be able to take further questions. There are many questions, but because of paucity of time, we'll not be able to do further questions. Now, I would like to thank Professor Balachandran and Professor Balraj Chauhan for their thought-provoking insights on the issue. And as the International Teaching Month is organized by ILNU, keeping in mind the intellectual advancements of students, so now I request Supriya Julka, a student representative, to express the words of gratitude towards our experts and all present. Over to you, Supriya.
Before that, Supriya, may I take this opportunity to convey our gratitude and thanks to Professor Gopal Balachandran, Professor Balraj Chauhan, especially Chauhan sir, you are here with us on these during this odd time, 7:30 is generally probably the dinner time and all. And thank you, Professor Gopal Chandran, for sparing your valuable time. I know you may be very busy and the sessions are also going on. So thank you for being with us. Yes, over to
My pleasure. Thank you.
Yes, Supriya, you need to unmute yourself.
I, Supriya Julka, on behalf of the students of Institute of Law, Nirma University, would like to express my heartfelt gratitude towards esteemed dignitaries, Professor Gopal Balachandran sir and Professor Dr. Balraj Chauhan sir, who spared their time from the busy schedule to grace the occasion and sensitize all of us regarding the issues and challenges which are faced by the poor people in defending themselves in the US and the Indian legal system. This is a contemporary problem in the present world state, and we students, as upcoming lawyers, hold the responsibility to address and eradicate these issues faced by the poor people in our profession. Your insights on the issue have enlightened our minds. Thank you for sharing your opinions with all of us today. Further, I would like to specially thank Professor Stephen Barnes, sir, and our Director and Dean, Professor Dr. Purvi Pokhriyal, ma'am, for giving us all the opportunity in these uncertain times so that we can learn virtually. Further, I am immensely thankful to Professor Neeraj Gupta, sir, for moderating this session. And events like this don't happen overnight, and we're fortunate enough to have backed by a team of proactive and dedicated technical and administrative staff of our institution. I would like to thank Gagandeep sir, Ramesh sir, Fayaz sir, and Digin sir, who made every effort to organize this event smoothly. Thank you all.
Thank you.
Thank you, Purvi.
Thank you,
Thank
sir.
you, Neeraj. Thank you, Professor Ven. And thank you, Professor Subramaniam. We'll meet.
You're welcome. Thank you.
Bye-bye.
Bye-bye.
Bye.
Good night.
Bye.
Have a
Thank you.
great
Good
day.
night.
Gopal.